Subscribe to get contents via mail. Purchase shorthand journals and more.
Learned counsel appearing on behalf of the accused has vehemently submitted that, as such, there is no evidence against the appellants that they caused any injury to the deceased and or participated in commission of the offences for which they are convicted. It is submitted that, in fact, the appellants were there as office bearers of the union, and when the talks were going on, the labourers gathered and attacked. Is submitted that, in the fact, the appellants tried to control the situation. However, the mob attacked the deceased managing director, who succumbed to the injuries. It is submitted that there is no evidence that the appellants herein even instigated the mob. It is submitted that, even considering the deposition of the eyewitnesses as it is, it cannot be said that the appellants have committed any offence for which they are convicted, more particularly Section 302 IPC. Learned counsel appearing on behalf of the appellants has taken us to the deposition of the relevant witnesses. On the other hand, learned counsel appearing on behalf of the state while opposing the present appeal has submitted that it has come on record from the deposition of eyewitnesses PW3, PW4 and PW6 that the appellants, who were the office bearers, came out when the mob came, and then they spoke something in their own language. It is submitted that, therefore, the appellants are rightly convicted with the aid of Section 149 IPC. Learned counsel appearing on behalf of the state has taken us to the deposition. We have heard learned counsel appearing on behalf of the respective parties at length. We have gone through in detail the judgment and order passed by the trial court, as well as the impugned judgment and order passed by the High Court. We have also considered in detail the deposition of the relevant witnesses, more particularly PW3, PW4 and PW6, who were the eyewitnesses. On considering deposition of the eyewitnesses, nothing is forthcoming that the appellants caused any injury on the deceased and or participated in any manner in commission of the offences for which they are convicted. If the entire evidence and the deposition of the eyewitnesses are scant, it appears that, in fact, the appellants were present there as office bearers of the union. There were some disputes with respect to wages. Even as per the deposition of PW3, on being called, the appellants entered into the office room, but soon both of them came out and told the assembled labourers that the managing director would distribute their dues, and asked them to go to the place where dues were to be distributed. Despite the same, the labourers protested that they would not accept anything other than the full dues, and they started shouting. The other labourers, co-accused, snatched the carbine of the PSO, and to that the deceased managing director asked the appellant as to why the weapon of PW3 was snatched, he being a public servant.